to live session for the contracts course. This is the second week of our course in summer term 2022. Let's look at our overviews and our objectives. We're going to defend a statement of consideration, learn how to create a paralegal's intake form based on a written scenario or a legal case, rewrite contract terms based on that intake form that the client and the paralegal filled out, correct defective terms using the intake form, and then research possible remedies for breach of contract. Does that sound good, Amanda?
Sounds wonderful.
Perfect. What are our assignments for Module 2? The first is to read in the textbook chapters 3 and 12. I find the textbook is really, really good. And then we're going to look at Restatement of Contracts, Chapter 4. The restatement is simply like a treatise or an encyclopedia where you can look up different contract topics. We're going to look at remedies under the Uniform Commercial Code, Article 2, Part 7. And right now we're having our Module 2 live session. And to get credit for this live session, you will need to submit the correct answer to the live session question by Sunday at midnight Central Standard Time. This week, as usual, you have a written assignment on remedies that is due Sunday at midnight Central Standard Time. So this is our introduction to the Uniform Commercial Code. When I was in law school, we had one class just called Uniform Commercial Code, where we just looked at the Uniform Commercial Code for a semester. So that was probably like September, October, November, December, 4 months just looking at the Uniform Commercial Code. And a very boring person taught the class. He also wrote the textbook that we used. So I'm very familiar with the Uniform Commercial Code. What the Uniform Commercial Code is it is a set of special rules that apply to contracts for the sale of goods greater than $750. The purpose of the Uniform Commercial Code is to uphold contracts for the sale of goods and to make it easier to perform those contracts, to loosen up some of the common law rules, and to create special remedies when a sales contract may be breached. So this is discussed in your textbook, but we're going to be looking at some of the buyers and sellers remedies under the UCC in case there is a breach. So in every contract, you have to have 3 elements: offer, acceptance, and consideration. Well, usually the parties to a contract owe the duty to perform the obligations and promises that are specified in the agreement. You can find that in UCC 2-301. The seller's general obligation is to transfer and deliver the goods to the buyer. These slides will also talk about lease agreements because, sometimes people are leasing cars these days. They're leasing equipment. And we just want you to understand that a lease may also be covered by the Uniform Commercial Code. So in general, the buyer's obligation under a contract is to accept and then pay for the goods. What happens if the buyer does not pay for the goods? What happens if the seller does not deliver the goods? Well, when one party breaches the contract, the UCC provides the injured party with a variety of remedies. The remedies are designed to place the injured party in as good of a position as if the contract had been perfectly performed. The best remedy will depend on the circumstances of the particular case, and sometimes the buyer or seller may be able to choose the remedy. Again, the performance of obligations and the remedies that are available are discussed in Chapter 12. So you will want to review that. Even if you don't have time to read the whole thing, just review the sections on the UCC remedies. Let's see what the seller's obligation is. In any contract for the sale of goods, suppose you have somebody, a developer is going to build a mall. Well, you're going to need drywall, you're going to need cement, you're going to need nails, you're going to need doors. If someone agrees to provide the doors, then they are the seller of the doors and they have to tender delivery. So a seller of goods must transfer or deliver the goods to the buyer in accordance with the sale contract. This is the basic obligation of a seller, is to tender delivery. Tender of delivery requires the seller to put and hold conforming goods at the buyer's disposition and give the buyer any notification reasonably necessary to enable delivery of goods. The parties may agree as to the time, place, and manner of delivery. So any questions about how you would tender performance, Amanda?
I'm sorry, say what?
That's okay. So let's assume, Amanda, that we have a contract. The contract is for you to sell me your computer for $500. I save up $500 and then I call you, hey, I'm ready to buy your computer. How would you tender delivery? How would you deliver the computer?
I would most likely probably ship it to you.
Yes. Under the UCC, I think shipping is reasonable. There are different ways you can tender delivery. You could tell me to come to your house and pick it up. Like if we lived in the same city, that might be how delivery is tendered. If we agree to that, if we agree the place of delivery is your residence, then that's what I would have to do. I'd have to come to your house with the money and pick it up. And you would just be making the computer available, you know. If I
Yes.
came to your house and you said the computer is not available, my husband's using it to work. That would be a breach of contract, probably, because you would not be tendering delivery. Does that make sense? Okay, so let's talk about some of the seller's rights. Under the UCC, the seller who delivers non-conforming goods has an opportunity to cure the non-conformity. Although the term cure is not defined by the UCC, it generally means an opportunity to repair or replace defective or non-conforming goods. So let's get back to a development situation. So if a building is or a mall is being developed and a contractor is supplying nails, and the contractor is supposed to be supplying platinum nails. The contractor supplies small nails that are made out of tin. Those would be non-conforming goods. So under the UCC, the buyer has to notify the seller, look, your goods are non-conforming, but I'm giving you the opportunity to cure. And that opportunity to cure is spelled out in UCC 2-508. A cure may be attempted if the time for performance has not expired and the seller notifies the buyer of his or her intention to make a conforming delivery within the contract time. So your module 2 assignment, Amanda, is going to be about the seller's right to cure a non-conforming delivery of goods. Does that sound good?
Yes, that actually makes perfect sense.
Awesome sauce. Okay, well, the buyer has obligations too under the UCC. In the event that the parties are engaged in a commercial contract for the sale of goods. Once the seller has delivered the goods, the buyer is obligated to accept the goods in accordance with the contract. That means if the seller sends a shipment of goods, the buyer can't just reject it. No, I didn't order these. I don't want it. That would be the wrongful rejection of a proper tender of goods. So the buyer does have a right to inspect the goods that are tendered, delivered, or identified in the contract prior to accepting and paying for them. So the goods are shipped, the buyer can open the box, can look at them, can inspect them, make sure that they're conforming, and then, and then pay for the goods. If the goods are shipped, the inspection may take place after their arrival. If the inspected goods do not conform to the contract, the buyer may reject them without paying for them. So the buyer has the right to reject a non-conforming delivery. And that's UCC 2-513. And again, you can read all these UCC provisions in chapter 12 of your textbook. They're also on the open web. What does the buyer have to do? Well, the buyer has to pay for the goods. Goods that are accepted must be paid for. That's UCC 2-607. Unless the parties to a contract agree otherwise, payment is due from a buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. Buyers often purchase goods on credit extended to the seller. Unless the parties agree to other terms, the credit period begins to run from the time the goods are shipped. So that's good to know. A lessee must pay the lease payments in accordance with the lease contract. Like if somebody is leasing a car, I have friends that do that. Instead of buying a car now, they just lease it for a few years and then take it back to the dealership. So they would have to make those payments in accordance with the lease contract. And then the dealership would need to deliver the car according to the parties' agreement.
Makes sense.
Good. I would never lease a car. I need to know that I'm owning whatever it is I got. But I know people that lease.
I own 2 vehicles, so yeah, I couldn't do the whole lease.
Yeah, after, because sometimes you get to the point where you've actually paid for that car and you don't have a car payment, and that's pretty awesome. You
Very.
own the car. Great. So let's talk about what happens in the event of a breach of contract. So if a buyer does not get the proper goods tendered, a buyer who has accepted goods may revoke his or her acceptance if the goods are non-conforming. So if you order, say, a French door to put on your house, and you end up with some kind of barn door instead. Barn doors do look good on certain types of houses, but you wanted a French door. So you can revoke your acceptance when you realize that the wrong door has been shipped. That means the goods are non-conforming. The non-conformity substantially impairs the value of the goods, and one of the following factors is shown. The seller's promise to timely cure the non-conformity is not met. The goods were accepted before nonconformity was discovered. The nonconformity was difficult to discover. The goods were accepted before the nonconformity was discovered. The seller or lessor assured the buyer that the goods were conforming. So yeah, I mean, sometimes I'll accept a shipment of something without opening the box. I'll just say, thank you, close the door. I may not find out until later on that they've sent me somebody else's computer. So under the UCC, you can revoke your acceptance if the goods are non-conforming. So the UCC is pretty awesome. It does give buyers and sellers special remedies, special rights. And it's just to encourage the free flow of commerce, to encourage people to contract with the expectation of, hey, if people are doing business in a commercial context, we know what the rules are. They're the rules that are spelled out in the UCC. So when buyers and sellers start to ship goods and purchase goods and things are being shipped across state lines, everybody knows what to expect. They just have to follow the UCC rules. Does that make sense, Amanda?
Yes.
Because without the UCC, without the Uniform Commercial Code, we would be left with 50 states plus the District of Columbia, all having their own rules about how to enforce contracts, because contract is a matter of state law. In many instances, states have different rules. So when people start doing business across state lines, they won't necessarily know what the rules for shipment are, what the rules to cure, what the proper way to tender delivery is, how many days they have before they have to notify of a nonconformity. But with the UCC, everybody knows what the rules are when you're buying and selling goods. So it really helps facilitate commercial transactions, which are absolutely critical to our economy. What can the seller do? Well, the seller has the right to withhold delivery. Delivery of goods may be withheld if the seller is in possession of them when the buyer breaches the contract. This remedy is available if the buyer wrongfully rejects or revokes acceptance of goods, fails to make a payment when it's due, or repudiates the contract. If part of the goods under the contract has been delivered When the buyer materially breaches the contract, the seller may withhold delivery of the remainder of the affected goods. A seller who discovers the buyer is financially insolvent, maybe they file bankruptcy before the goods are delivered, may refuse to deliver unless the buyer can prove or pays cash for the goods. So if the buyer and seller have an ongoing agreement to ship wine to a restaurant, all that the restaurant needs to purchase is being shipped from a lovely vineyard in California. But the restaurant files for bankruptcy. The vineyard does not have to keep shipping, tens of thousands of dollars worth of wine to a restaurant if they find out the restaurant has filed for bankruptcy. They can refuse to deliver unless the buyer is willing to pay cash. So that's a UCC rule, 2-702. So do you think it makes it easier to contract with the UCC rules in place, Amanda?
I do. It's almost like here to follow a statute versus all the other laws that I have.
I really like certainty, and that's what the UCC provides. Everyone knows if you have a commercial contract for the sale of goods over $750, the UCC applies. Every state has adopted some part of the UCC, or if not all of the UCC. So everybody knows what the rules are for contracts for the sale of goods. One thing that you're going to need to know for your quiz, which I think is in week 3, are the buyer's remedies. The UCC provides a variety of remedies to the buyer when the seller breaches the contract. 1, a right to reject non-conforming goods or improperly tendered goods. A right to recover goods from an insolvent seller. The right to obtain specific performance. So specific performance is the court ordering the seller to perform the contract. Specific performance is very rare. Usually in the event of a breach of contract, the buyer will get what's called expectation damages. And that's putting the buyer back in place as if the contract had been performed, giving them the value of the services that they were supposed to get. However, if the subject matter of the contract is rare, for example, if I purchase a Monet painting, Monet is my favorite French painter. Those paintings are worth 10, 20, 30 million dollars, and they're rare. Monet has been dead since the 1900s. So Monet has been dead for 100 years. But his art is still very valuable because there's a group of people that like to collect French Impressionism art from the 19th century. So if I contract for the purchase of the Monet painting, it is not delivered, I can go to the court and request specific performance and say, look, judge, there's no way for me to get what I have bargained for unless the seller is ordered to deliver the item. And when the court orders someone to do something like specific performance, and then the seller doesn't do it, what do you think happens then? The court orders someone to do something and they don't do it. What do you think happens, Amanda?
There would be some cure to be put in place at that time.
Let's use an example. If former President Trump is ordered to appear in court and he doesn't do it, what is that?
He would actually be held in contempt at that point.
Brilliant. That's contempt of court. So if the court orders specific performance of a contract and somebody doesn't do it, that's contempt of court. There have been countless instances where courts have ordered people to do things and they don't do it. That is a very serious offense. I could go into detail so many ways, but I won't even do that. But especially if it is a federal judge, because they are seen to be of even greater authority than a state court judge. But anytime someone disobeys the order of a judge, that's disrespecting the judicial system of the United States, and the government of the people, for the people, and by the people. It's disrespecting democracy. It's disrespecting the U.S. Constitution, which establishes a judiciary and a court system for resolving disputes. Someone's ordered to appear in court or to turn over something as a judge would like. They fail to do it. That's contempt of court. That is punishable by incarceration. So no one wants to do that. And, people are going to find out that it's going to get to that point where people disrespect the authority of the judge. They're held in contempt of court. They will either pay a fine every day or they will sit in jail for disregarding and disrespecting the court's order. So anyway, that's what would happen in the instance that the subject matter of the contract is rare. The buyer says, "Look, judge, I can't get these rare coins anywhere else." The buyer's holding on to them. I can prove that we had a contract. I can prove that I held up my end and the seller still didn't deliver. The judge can order specific performance. Sometimes land is considered rare, Amanda. Somebody has a contract to purchase land. Maybe I want a beautiful places for my horses to roam around in Kansas, and I have a contract for the sale of land, and we close on the deal. And then the seller doesn't tender the possession of the property to me, doesn't deliver the deed. I might go to court again and ask for specific performance and say, Your Honor, every parcel of land in America is rare. I wanted a parcel of land where I could have feed my horses and my chickens and my livestock. And I bought this beautiful piece of land in Kansas, and the seller did not hand over the deed. The judge could order specific performance. And if people do not do what that judge says, it's not going to be pretty. It's not going to be pretty. So let's talk about the other buyer's remedies. The right to cover, which is the ability to obtain substitute goods. So again, if I am trying to buy a French door for my house and I get a barn door delivered instead, I can cover from another seller. There's plenty of people who sell beautiful doors for houses. So I would simply be expected, or I would have the right to seek substitute goods from another seller, and that's covering. Cancel. If the seller does not deliver the goods, I can cancel the contract and fail to pay. I can also sue for money damages if I've already paid, or if I suffer from lost profits because I did not get the item that I needed. Maybe I needed something for my business. If I run a restaurant and I needed a new soda machine, and I did not get the soda machine and I lost profits, I can sue for lost profits. So the buyer's remedies are pretty good under the UCC. This is a table that you will want to memorize. It spells out the situation and then the buyer's remedy. Seller refuses to deliver goods or delivers non-conforming goods, and then there's the buyer's remedy. Seller tenders non-conforming goods and the buyer accepts them. Buyer can sue for damages. Seller refuses to deliver the goods and the buyer wants them, sue for specific performance. So UCC is very complete in its remedies. Let's talk about your Module 2 assignment. So in our scenario, the buyer and seller have a master contract that is complete and enforceable. 20 customized parts have been ordered from careful seller by the buyer. The price is $1,000 a unit. They are customized with painted advertising for the buyer's business. 20 parts have been shipped. 10 are rejected, though. 10 are accepted. The buyer has not paid for any of the parts. The buyer received the shipment, held them for 10 days, returned the 10 rejected parts with a message that said they were too large for use, and that the buyer intended to use acceptable ones and obtain cover for the other 10 parts from a different company. The contract says the seller has the full right to cure any defects in parts within 10 days of notification of the defect to the seller, and the return of the defective parts. If the seller does not cure within 10 days, the buyer may obtain cover parts from any other source. This paragraph of the contract is not intended to add or change a UCC remedy other than to give time limits. So that's a provision in the contract that's very standard. This paragraph is not intended to add to or change any UCC remedies. So here's what you're being asked. In your written assignment, you'll want to write this up as a memo. Define cover and cure in your own words. Cite to the section of the law that you were paraphrasing. You can basically cite to the UCC provisions on cover and cure. The next thing is complete the italicized portions of the partially completed IRAC table. Use the scenario, the UCC, and the contract to complete the IRAC table. So once again, you're completing an IRAC table. And then select a way that you can fix this clause 3 of the contract to provide more clarity. Any questions about that assignment?
I actually do not have any questions at this moment.
Great. Let's talk a little bit about IRAC, because this assignment is asking you to do the IRAC as opposed to the country Iraq. IRAC is an acronym. It stands for Issue, Rule, Analysis, Conclusion. The use of IRAC is popular among judges, attorneys, and students. It is a way to show application and analysis in a clear way. Begin by reading the facts of the case. So when you're researching a case on Lexis.com, if you're researching a case about UCC remedies, you want to find out what issue the court is addressing in that case. We've seen a lot recently from the Supreme Court. In every case that the Supreme Court has heard, they're focused on one issue. Maybe it's an issue they really shouldn't be focused on. But whatever it is, when the court renders an opinion, they're focused on one or two main issues. So it is very important for you as a student of the law to learn what issue is being focused on in the case that you find when you're researching. Complete your research to determine a likely rule. A rule must have an acceptable source that must be cited. So if I was doing research on the UCC, I might find a case that talks about the seller's right to cure. So if I did research on Lexis and I just did a natural language search, seller's right to cure, and I looked for the most recent case, I would want to make sure that that case had an issue where the issue was how long the seller had to cure to provide conforming goods after a non-conforming shipment, or how long does the buyer have before notifying the seller of a non-conforming shipment. I want to make sure that my case is on topic and on point. So when you find out what that issue is, you want to use that as your issue when in the IRAC. The rule you can also ascertain from the case or the Uniform Commercial Code or a statute. The rule is the seller has a reasonable time to cure after receiving notification from the buyer of a non-conforming shipment. Then you will take the facts of your case, the case that is walked into your office that your supervising attorney wants you to work on, and apply the standard and established rule to the facts of your case to tell your client what they should do in their situation. You may find that the rule doesn't work. If not, say that, and keep doing research until you find a rule that applies. If you need more facts, you can put that into the application part of your analysis of the IRAC issue rule analysis. The analysis is really the most, the part of the IRAC where you really put your thoughts in. The issue is simply restating the issue in the case. The rule is simply restating the rule that is in the case or the rule that's under the Uniform Commercial Code. But the analysis is all your critical thinking and your power of discernment. When you apply the facts of your client's case to the established rule to come out and reach a conclusion as to what needs to be done in your case according to the rule of law. So that's IRAC. The better you get at it, the better you will be as a paralegal. So complete the IRAC analysis using the form provided in the Module 2 written assignment. Download the form, fill in the applicable UCC rules, and apply your conclusion. I would like for everyone to read all the lesson notes for Module 2. There's some really good information about contract remedies and business cases. There is some discussion about the importance of grammar and language, spotting errors, naming errors, and we'll talk more about that in the upcoming weeks. And that is all, folks. So your live session question is, what does UCC 2-712 say? You can find that on the web, or you can find that in chapter 12 of your textbook. So the question is, what does UCC 2-712 say? Just type that into the live session answer box, and you will receive credit for attending the live session as long as your answer is correct. Be sure to submit that assignment as well as your memo by Sunday, July 17th. Any questions, Amanda?
I do not. I think you actually answered them for the majority of it. So yeah.
Good. So yeah, if you have any questions or concerns, feel free to reach out. Send me an email, text message. My number is 702-241-3415. I'm only a phone call away. And I look forward to receiving everyone's assignments. And your assignments for Module 1 will be graded by Friday at midnight Central Standard Time. So you will wake up Saturday morning and have all of your grades for Module 1.
All right. Well, thank you.
Thank you, Amanda. Have a great night.
Thank you. You too. Bye-bye.
Bye.